and we will open the hearing on Senate Bill 104. If we could have a bill brief from the reviser, Mr. Thompson.
Thank you, Madam Chair, and good morning, committee. Senate Bill 104 requires a court order to be issued directing a child to remain in a present or future placement for certain children in need of care when certain findings are made. The bill amends KSA 38-2260. That's a part of our revised Kansas Code for Care of Children. Current law in subsection A provides that a court may enter an order directing a child to remain in a future or present placement if the court finds that the child is a child in need of care for certain reasons and that the child is not likely to be available within the jurisdiction of the court for future proceedings. The bill changes the word may to the word shall so that a court is required to enter the order if the findings are made as they would be under current law. So permissive order becomes a required order. And I will stand for questions.
Thank you, Jason. Committee, do you have any questions for the reviser? Seeing none, then we will ask our first proponent conferee, Mr. Sean Brandmall from North Central Kansas Regional Juvenile Detention and Geary County Secure Care Center. And he is appearing by WebEx this morning. So please introduce yourself and welcome to committee. Okay, are you able to activate your microphone, Mr. Brandmall?
Yeah, unfortunately, I think it mutes me automatically. You have to keep an eye on me. I'll try to get this. Can you hear me okay?
We can, yes. Go ahead. Please introduce yourself and welcome.
Okay. I'll do it a second time because you didn't hear me the first time because I was muted. My computer mutes me periodically. No, and I'm not doing it. But if it happens again, please let me know. My name is Sean Brandmall. I'm the director of the Juvenile Detention Center in Junction City, the North Central Kansas Regional Juvenile Detention Center. We did start a new secure care center. And what we found when we did that was Senate Bill 367 prevented judges from holding sink kids in juvenile detention anymore. And so they stopped putting no-run orders on the kids. And so when they put a child in a placement, the child would run, and it happened over and over again. And then eventually the judge says, oh, hey, there's a secure care center out there. Maybe we should put a no-run order on them. I've tried to inform the judges that, hey, we are out here and you can put no-run orders on the kids. And that way when they run, they don't have to wait, 5 or 6 times before you finally have enough runs to qualify the youth for secure care. So that's kind of what I'm hoping to do. I couldn't get the judges to do it on their own. So I'm hoping that if we just make it a formality to put a no-run order on every youth who's placed, then hopefully when the youth runs a couple of times, then he'd be eligible for secure care. Obviously, youth on the run can be very dangerous to themselves, sometimes to others, and I think they're much better off if they're placed here where we have therapy and school, and they don't fall behind, and they get the help that they need.
Thank you, Mr. Brandmall, and we'll have committee questions after the testimony from all the conferees on the proponent side have had an opportunity. So next then we will welcome Jessica Lucas on behalf of Ember Hope Youthville to the podium, and please introduce yourself and welcome to committee.
Good morning, Madam Chair. My name is Jessica Lucas, and I am here today on behalf of Michaela Sandate from Ember Hope Youthville.
Thank you, and just a little tip, if you could make sure you speak directly into the microphone so those online can hear you.
Blue light is on, but I'd have to be real close to this mic.
There we go. Thank you.
For those of you that aren't familiar, Ember Hope Youthville is a facility in Newton, Kansas that is a nonprofit child welfare agency that served the community for over 90 years. It's referred to, the Ember Hope calls itself an organization committed to diligently work to lead healthy change for children and families by offering innovative, trauma-sensitive programs rooted in faith. Ember Hope has provided secure care services to females in the custody of the state since 2010, and that's why we're here today to profess our support for this bill. Because of the extensive history of serving this population, we do believe secure care is a necessary level of support needed for this population and recommend the passage of Senate Bill 104. And I will stand for questions at the appropriate time.
Thank you. Do we have any other proponent conferees in the committee room or online? Seeing and hearing none, then we will open it up for committee questions to our conferees. All right, I have a question. If you could just explain, either Sean or Jessica, without Senate Bill 104, we're then left with our hands sort of unable to help these kids who are in need of continued placement without this order. Kind of tell us what gap or what need this particular, the language change from may to shall would provide to our youth. Jessica, if you wanted to come back, Ms. Lucas, that'd be great. Or Mr. Brandmall, either one.
I'm more than happy to do it. Basically, okay.
Great, thank you.
Basically,
Please introduce yourself again.
I'm sorry, Sean Brandmall, Director of the Juvenile Detention Center, North Central Juvenile Detention, and Geary County Secure Care Center. Basically, the big gap it fills is the fact that most judges don't seem to know that there's a secure care option, and so they feel kind of helpless. And so we're trying to just make it a formality so that the judge automatically puts a no-run order in and then eventually figures out that, hey, there's a secure care out there that I can place this youth in if he continues to run from placement, placing himself in danger and, of course, falling behind in school, especially, and, of course, therapeutic intervention.
Thank you. Ms. Lucas, did you have additional testimony you'd like to offer?
I would just say we see this as another tool in our toolbox to be able to help kids that are in crisis and have ran.
Thank you. Any questions from the committee? Yes, Senator Wilborn.
Thank you, Madam Chair. Ms. Lucas, a question. As a human nature, could this word change, could it end up being abused the other way by frequently overruling their jurisdiction? Am I making sense?
You introduce yourself again, please.
It's Jessica Lucas with Ember Hope Youthville, and if I'm understanding correctly, Senator, you're asking if is there concern that going from may to shall could result in children being required to stay in a facility and there not being enough gray. And I wish my client were here to answer the nuances of all of this, but it's been our experience that the changes to Senate Bill 367 have made it difficult to get kids the help that they need. And so we would like to be able to have some tools to keep them from running on multiple occasions. But I would defer to Sean, who really is doing this work on the ground more so than I am as their advocate, since Nikayla is not here to answer those specific questions.
Sure. Thank you, Ms. Lucas. And Mr. Brandmall, if you can answer.
Yes, Sean Bramall, Geary County Secure Care Center. There are protections built into the statutes to make sure that this is not being abused. Mainly, the youth has to run twice. Then the question becomes, how many times should a youth be able to run before we finally have to say, okay, we need to do something different to give this child the help that they need?
Thank you.
Thank you. Was this brought to us also, this may be a question for the reviser, was this brought to us by the Kansas Judicial Council, or did this originate from somewhere else? Is that correct, Mr. Reviser?
Thank you, Madam Chair. This is Jason Thompson with the reviser.
I think I answered my own question. I looked at my notes, and I'm thinking it's originated from somewhere else. So is the current state, if I'm correct, regarding Senate Bill 367, that if we change the may to shall, then currently we have you've got to run away from a facility where you've been ordered to remain as a youth 3 times before the judge or the court could require remaining in a secured placement. Is that the current state of the law? And then we're changing from the may to the shall, that it can be changed from the first time that a youth runs away from a secured facility, that the judge can take action. Is that what we're doing here with the Senate bill, or I'm not understanding it? No, you're shaking your head, Mr. Brownmall, if you could clarify.
Right. The youth has to have run from placement twice, not just one time. And so that's not being changed at all. There has to be 2 runs, and then the 3rd time he becomes eligible. If the no run order is in place, he becomes eligible for secure care if that's what the judge decides.
And this then gives the court some additional tools, if you will, to protect the youth. And we've got some measures in place that, like was brought up in the question, that doesn't get abused. Mr. Brownmall, if you can answer.
Yeah, I mean, basically, if a youth runs twice, the state of Kansas has passed this law that basically says that's enough. After the 2nd run, we need to have at least have the option for different measures to help these kids.
Thank you. Committee, any further questions? All right, seeing none then, are there any neutral conferees in the committee meeting room or online? Seeing and hearing none. Do we have any opponent conferees? We have Ms. Tanya Keys, Deputy Secretary, Kansas Department of Children and Families. And Ms. Keys, I think you're probably on WebEx, but please introduce yourself and welcome to committee. Ms. Keys, if you're speaking, we're not able to hear you. You might have to unmute your microphone. No, she's not present on WebEx. I'm hearing from Frank, our IT person. Do we have her signed in on WebEx? Can we tell? Okay, then I'll ask, are there any opponent conferees in the committee meeting room or on WebEx? Seeing and hearing none. Committee, we did have Ms. Keys from the Kansas Department of Children and Families signed up as an opponent conferee, and she's not in the committee meeting room or on WebEx, but I think it's important that we have the opportunity to hear from her, so we will, we're hearing that her computer has crashed and she's trying to get back to the meeting. So have we had any written testimony from Ms. Keys? Is it in our committee folder? Okay, you do have the opponent written testimony from Ms. Keys in your committee folder. We will circle back and see if by the time we're done with our other business today, we can come back and have Ms. Keys testify. So if you're able to get on, Ms. Keys, please stand by. And for now then, we will close the hearing on Senate Bill 104 to be continued later in this hearing, if we can get Ms. Keys on the line. We will then open the hearing on Senate Bill 106. If we could have a bill brief, and I will thank the conferees who did appear on Senate Bill 104 today. Thanks very much.
Thank you.
You bet. Thank you. Senate Bill 106 then, Mr. Thompson from the Revisor's Office with the bill brief.
Thank you again, Madam Chair. Jason Thompson with the Revisor's Office. Senate Bill 106 enacts the revised Uniform Law on Notarial Acts, repeals the Uniform Law on Notarial Acts, and repeals other provisions related to notaries public in Article 1 of Chapter 53 of our statutes. To many of you, this bill may look familiar. This was a reintroduction of House Bill 2713 that this committee saw and recommended amendments to last session. The bill in front of you reflects all of the amendments that were made on both the House and Senate side. So this is the bill as you would remember it when you left at the end of the session. So I will not go into too much detail. There's quite a bit in the bill brief if you want more. As with all uniform acts, we have a name for it. We have definitions. It does provide for prospective application of the act. So it's on and after January 1 of 2023. So it's delayed for a little while here. There are various provisions that are covered in the current act that are renewed or revised for the new act, including who can be a notary, how a notary performs their duties, what kind of records they have to keep, etc. I will highlight section 15, which allows for remotely located individuals to comply with the personal appearance requirement that we have by using communication technology to appear before the notary public. It also has some circumstances under which a notary located in this state can perform a notarial act using communication technology for a remotely located individual and the requirements to do that. This is probably the key provision you've been hearing about remote notaries and how we did some of that under the executive orders and other statutory provisions that we enacted during this COVID-19 public health emergency. But this is the ongoing provision that you've been hearing about for remote notarization. I'll skip then to the end of the bill brief and note that the commission of a current notary public that's in effect on the January 1 of 2023 when this goes into effect will continue until the expiration date of their commission. And if you apply after January 1 of 2023, you would have to comply with the new act. And anyone performing notarial acts after that date would also comply with this act, but it does not affect the validity of a notarial act performed before the effective date. So any notarizations that happen now under the current act remain valid. Any notarizations going forward after January 1 of 2023 would have to comply with the new act, as would all notaries seeking to have a commission. The last thing I'll say is that there are some amendments to other sections near the end in sections 32 and through 41. So I've highlighted those in the bill brief. Essentially, those are mostly updates to these statutes to reference the new revised uniform law. A couple of substantive changes that I highlighted in the bill brief, but mostly a change in the name of the act where it appears in various statutes, and that adds the length to the bill. I noted that most sections go into effect on January 1 of 2023, but the bill itself goes into effect on July 1 of 2021. And that's because a couple of sections requiring the Secretary of State to adopt rules and regulations go into effect this July. And then those could be promulgated in preparation for the rollout of the act in 2023. With that, I'll stand for questions.
Thank you, Jason. Committee. Yes, Senator Haley.
Thank you, Madam Chair, and thank you, Mr. Thompson. You referenced, I remember hearing this before. What happened? You did reference last year's bill. Procedurally, what happened to the measure last year?
Mr. Thompson.
Thank you again, Madam Chair. Procedurally, I think all that happened was the bill got sent to the Senate floor and it died on general orders due to the adjournment of the session early. We did do one provision in the emergency bill, House Bill 2016, in the special session to validate notarizations that were happening under the executive order. That was the only action we took on the notary issue. So essentially, this bill just became a casualty of the early end to the session, is my recollection.
Thank you, Mr. Thompson and Madam Chair. Is there anything, if you know, working its way through the House similar to some of the provisions that are included in this measure?
Mr. Thompson, if you can answer.
Thank you, Madam Chair. As far as I know, the proponents of this bill only requested it on the Senate side. They started here where they ended last time, and there is no comparable House bill on this issue.
Thank you, sir. Thank you, Madam Chair.
Senator Pyle.
Thank you, Madam Chair. Jason, I'm just looking at some of the sections, new sections. I'm just curious, is a tribal notary or 13, where's that go? A federal notary, or if you get to new section 14, the multinational, international, foreign state notaries, they all subject to our requirements for a notary?
Mr. Thompson, go ahead.
Thank you, Madam Chair. Jason Thompson again. I know I noted in the bill brief that those provisions are there. Let me see what I said about them. So the sections that I believe Senator Pyle is referring to are, so section 11 is the one that provides under what circumstances a notarial act performed in another state has the same effect as if performed in this state. Section 12 is the same for federally recognized Indian tribes, Section 13 for federal law, and Section 14 for a foreign state. And so each of those sections has requirements that have to be met so that that notarial act that occurred in that other jurisdiction can be treated as though it happened here. Without digging into the weeds too much, maybe that gives you an answer, but we can dig into it a little more if you'd like.
Madam Chair, I'm just curious as to what the qualifications are for a notary in a foreign state. I would not think that they would be under the same guidelines as someone in Kansas or maybe even a federal notary. I don't know. That's what I'm trying to inquire. Under current law, without these revisions, do we allow that action with a foreign state or an international notary?
Mr. Thompson?
Madam Chair, Jason Thompson again. I hope the proponents can speak to the transition from the current law to the new law. I'm just not familiar enough with that. But I can tell you under the principles of comity, C-O-M-I-T-Y, we generally recognize valid acts by other jurisdictions in our courts and in our documents. And the requirements here in the bill are that the person has to be a notary public under the rules of that jurisdiction. So under the rules of the tribe or under the federal rules or under the rules of that foreign state. And if they do that and they meet the other requirements that are listed here in the section, we would treat that as a valid notarial act. And if they have, on the flip side of that, if they have the revised Uniform Act or even the Uniform Act potentially non-revised, they would be recognizing Kansas notarial acts in return, right? That's the comity principle at play.
Thank you, Madam Chair. Maybe the supporters of the bill can testify as to why, if this is normal that we accept those jurisdictions and their qualifications for their notaries, if there's any distinguished differences under these proposals and what current law is, and how do we know, do we know what those jurisdictions guidelines are for a notary in Timbuktu? If we're going to accept that, I understand the courts could look into that, but if those are the guidelines for a notary and it just says sign up, I'm a little concerned. Maybe we should make them. Well, anyway, I just want to hear what the proponents say. Thank you, Madam Chair.
Thank you, Senator Pyle. Thank you, Mr. Thompson. And yeah, we'll need to hear from the proponents about foreign states, both outside of Kansas, in the United States, and then other countries, if we're truly talking about foreign countries as well. Do we have any other committee questions for the reviser? I just want to follow up, Mr. Thompson, with Senator Haley's question. How did it pass the House? Do you know the vote on the House floor last session?
Yes, thank you, Madam Chair. Jason Thompson again. I have the history up here. Flip tabs. Looks like on House final action, it passed 122 to 3.
Thank you. Appreciate that. And with that, then, we will invite our first proponent conferee to the podium. I believe he's in the committee meeting room, but probably online. James Concannon, Kansas Uniform Law Commission. Mr. Concannon, if you'll introduce yourself, and welcome to committee. And I think he's just providing written testimony. So committee will find written proponent testimony from James Concannon from the Kansas Uniform Law Commission. We will then hear from the next proponent conferee, Chris St. John, Kansas Land Title Association. If you'll introduce yourself, please, and welcome to committee.
Chairman Warren and members of the committee. My name is Chris St. John. I am the legislative co-chairman of the Kansas Land Title Association. KLTA has represented abstractors and title insurance agents in the great state of Kansas since 1907. KLTA supports Senate Bill 106, a version of the 2018 Revised Uniform Law on Notary Acts, or ROLONA, tailored for Kansas. Kansas patiently monitored legislation across the United States over the past 5 years, and as other states attempted to implement technology-driven notarizations. The Uniform Law Commission had the benefit of learning from some of the challenges faced by early adopters in crafting their 2018 revision, and were able to include provisions for what is becoming a new industry norm. KLTA's goal in supporting this bill is to work in partnership with interested parties, especially the Kansas Secretary of State's office, who must administer the law, to bring notarizations via two-way audio-video technology, remote online notaries, or RON, to Kansas in a safe and responsible way. Crossover of the membership between the KLTA Legislative Committee and the Title Standards Committee of the Kansas Bar Association made the KBA an important partner as well. Title insurers ensure, among other things, the validity of an acknowledgement on recorded documents. That is why our industry has such a huge interest in good legislation on this matter. KLTA believes the provisions of Senate Bill 106 for notarizations via two-way audio-video technology are robust, safe, and secure, platform neutral, and they provide the Secretary of State with a realistic mandate to promulgate rules and regulations to incorporate as necessary many of the national data and security standards that have been produced by the national standards groups. We appreciate the cooperation and leadership the Secretary of State's office has provided, as well as the advice and assistance provided by Professor Concanon and the Kansas Bar Association in crafting this bill. For your information, I've also attached a simplified flow chart of how a remote online notary might work. For the reasons stated above, the Kansas Land Title Association supports Senate Bill 106 and would encourage the committee to recommend this bill favorable for passage. Thank you for this opportunity to testify today. I would stand for questions.
Thank you, Mr. St. John. And committee, we'll go ahead and hear from all the proponent conferees, and then we'll open it up for questions. So with that, we will invite Mr. Mark Toom, Kansas Association of Realtors, to the podium. Please introduce yourself and welcome to committee.
Madam Chair, members of the Senate Judiciary Committee, thank you for the opportunity to appear today to express support for Senate Bill 106. My name is Mark Toom. I'm with the Kansas Association of Realtors. I'll focus my testimony on remote online notary services, and really besides calls from my members about making sure that real estate was deemed essential, no other topic generated more membership calls during the early stages of the pandemic than online notary. And as Kansans kind of started to limit their in-person interactions, those seeking notary services demanded solutions to meet the needs of the new normal. And real estate contracts, as you're all probably aware, that they generally include provisions that outline time-sensitive deadlines, and delaying the signing of contracts can have real consequences. CAR, along with a lot of other interested parties, reached out to the Secretary of State's office, who was already working on this issue, and trying to provide an alternative to in-person notary services during the pandemic. And those efforts eventually became portions of Governor Kelly's Executive Order 2020. And Kansas became part of a growing number of states that allowed for either a legislative solution or an executive action that led to the online notary concept, and I believe it's up to 48 states that have some sort of component to their law now. An executive order on the subject was an appropriate short-term solution. However, a long-term solution is needed that really matches the pace of business, and that's what this law does. So we wholeheartedly support it. So thank you for the opportunity to provide brief comments today, and I'm happy to stand for questions at the appropriate time.
Thank you, Mr. Toom, appreciate it. At this time, we will ask, are there any other proponent conferees in the committee meeting room? Yes, Mr. Miller, if you'll introduce yourself and welcome back to committee.
Thank you, Madam Chair, members of the committee. My name is Sean Miller. I'm with Capital Strategies, and I'm here representing the Kansas Land Title Association today. I believe you should have a copy of my written testimony in front of you, and I will not go by that point by point. Mr. Thompson did an excellent job of explaining the bill itself and the process and how we got here. And that's what I wanted to talk a little bit about today. I think I lead off by saying I'm not going to talk very much about policy, but given a couple of the questions, I thought perhaps I would address a few things as well. We did, in fact, begin meeting with not only the Secretary of State, but stakeholder groups in 2019 to deal with this, and that really was on the heels of the 2018 Uniform Law Commission development of a new Model Act. The first Model Act was adopted by the ULC in 1982, and Kansas adopted it in '84. And we have not adopted any of the revised Model Acts from 1984 until now. So we've made a few changes, we've tweaked a few things as technology and business has changed, but we really felt it was time for the full update. And what really brought that to us was the remote online notarization, which you've heard discussions of on a number of pieces. Virginia started that process in 2011. ULC process, as those of you who have served on the ULC before know, is very comprehensive. It takes years to get it all together, and so they came out in 2018. I believe to date, 12 states have adopted the Model Act, so we're still early, but we're not right on the cutting, bleeding edge where we maybe are going to have to learn from mistakes. We've really learned from what a lot of other states have done. We feel like that this Model Act is the right way to go. I did want to point out a couple of things as we've talked about this. Mr. Thompson pointed out that any notary who was a notary as of 1/23 or in 2023 would not be required to reapply. I also wanted to note that as we talk about remote notarization, notaries will not be required to be remote notaries. If you want to continue to be your in-the-book, hard copy notary, that's what you like to do because maybe you just notarize a few things a year for the business. This is not forcing you to become a remote notary. It's an option that people can choose to do. It requires some video logs and some documentation. So that's an option, not a mandate. And then a couple of other things as we look through. Mr. Thompson mentioned basically the last 12 pages of the bill were things that we added in the House committee because it is cross-references, one-off references primarily to where we talk about signature as required by 53-104. Well, we had to go back in and update all of those. So there's a lot of cross-references in there that were primarily the major changes made by the House committee. When we got to the Senate last year, the Vice President will remember this as chair last year, we had two national organizations that engaged and said, hey, we saw that you're moving through the process, you've passed the House, we have two suggestions for you that we think would make this a better bill. And they came in, they testified. We actually met with them prior to the hearing. We encouraged them to go ahead and testify and recommend those amendments, but we stated in committee at that time that we agreed with those amendments and we would ask the Senate committee to adopt those. Part of that is the use of seal and stamp. In Kansas, our stamp process, we're used to a physical stamp. Somebody stamps, then they sign, it has a date on it. As we move to more of the electronic things, you don't have a physical stamp anymore, you have an electronic seal, and we wanted to make sure we incorporated that language in there. The other thing is sort of full faith and credit is what I would call it, of other state jurisdictions' remote notarizations. We did not have language in there that was comfortable to the National Notaries Association and frankly to the ULC that our remote notarizations would accept remote notarizations that were done legally and according to the revised law in other states, Virginia, Montana, Texas, et cetera. So we wrote some additional language in there that made sure that we were recognizing remote notarizations done in other states. Finally, on this piece, before I address a question or two, I would say that we did, in fact, move forward with the executive order last year. We Secretary of State and the governor's office draft that executive order. That is a stopgap. That allows people, basically what it does is it waives the in-person requirement in our current notary law. It does not develop the comprehensive record-keeping, dual authentication, et cetera, that we feel like we need long-term. And so development of, or passage of this act and development of comprehensive rules and regs by the Secretary of State is still going to be really key and critical. The EO works as a stopgap. It is not a long-term solution. I did want to address a couple of things here real quick, if I could, particularly Section 14, some of those things. It shows up as new Section 14 in Senate Bill 106, but those are actually provisions that are in current law. But what we have done is taken a couple of sections of existing law and compiled them into one place, because that is how the Uniform Law Commission has written them up. So if you were to go back and look up Section 53-401, that was adopted in 1981 by Kansas. The dates I gave you earlier, we didn't adopt the uniform law until 84. That was the adoption by Kansas of the Hague Apostille Convention, which basically set forth exactly how we were going to accept documents from all of these foreign agencies. So that's been in statute since 1981. And then 53-507 was the original uniform law section that referenced that apostille of 53-401. So it was in two places in law in Kansas. We've combined those into one place, and that's why it shows up as a new Section 14. So nothing new here. We're not doing anything different. But the Uniform Law Act was adopted by us after the Hague adoption, and so we're just combining those all into one place for right now. As I look through the rest of it, I believe that the ULC and the National Notary Association I mentioned testified either neutral with a question for an amendment or opposed asking an amendment last year. I have circled back with both of those organizations, and they support Senate Bill 106 as written today, as do, I believe you should have a number of written testimonies from the organizations that we work with in developing this bill. You will note the effective date of 23 and some other sections Mr. Thompson mentioned go into effect on 1/1 of 21. That is to allow the Secretary of State to begin the rules and reg making process, but it's going to take about 18 months to get those rules and regs drafted and completed, and so that's why the rest of the act doesn't go into effect until 2023, hence the split effective date for this. So I'd be happy to stand for questions at the appropriate time, but I hope perhaps I addressed a few of those things.
Thank you, Mr. Miller. Are there any other proponent conferees in the committee meeting room or on WebEx? Seeing and hearing none, committee, I will direct your attention to your committee folder. You should have proponent written testimony from Katie Koppel, Deputy Assistant Kansas Secretary of State, Tim Reiniger, American Bar Association, Advisor to Uniform Law Commission, Joseph Molina, Kansas Bar Association, Kelly Van Zwal, Kansas Bankers Association, Stephanie Mulholland, Heartland Credit Union Association, and Luke Bell, Zillow. So with that committee then, we will open it up for questions to our proponent conferees. Do we have any committee member questions for the conferees? Yes, Senator Haley.
Thank you, Madam Chair. Mr. Miller, maybe I just didn't get it in my folder. Did you have any written? You didn't have a. Okay. Oh, it isn't, but it'll be.
So we will have some forthcoming written proponent testimony from Mr. Sean Miller that will be added to the committee folder.
I apologize, Madam Chair, if you didn't receive that. I think I emailed it just before the Super Bowl on Sunday, so people may have been a little bit busy.
And I did want to note, I do recall this, I served on House Judiciary, and I do recall we had robust debate about this, and I am glad to see that some of those concerns we had were made and put into this new Senate bill that we have. So thank you for the continued efforts of the stakeholders who have provided written testimony and proponent in-person testimony to get this bill positioned where it is. Senator Gossage. Oh, I'm sorry.
If I might, just briefly.
Senator Haley had a follow-up question.
Yes, thank you. And it's either for Mr. Miller or any of the proponents. The question kind of goes to, I think, what Senator Pyle was asking. If our standards are lessened, are those that are heightened, I guess, by other jurisdictions? I think, for example, the raised seal for notaries that are required in some jurisdictions for there to be comedy. In other words, if it comes from Kansas now with the adoption of this bill, that our notaries won't have the same level of authority or, I guess, respect through comedy in some other jurisdiction who might require the raised seal. So is there any discussion, I don't know if this is a question for you, Mr. Miller, or for any of the conferees among that national organization of our standards that would be adopted here by this bill, that their acceptance would be there as well, that we'd respect that they'd respect the laws of our jurisdiction.
Yes, thank you, Madam Chair. Senator, so a lot of what you're questioning right now were the issues.
Identify yourself, please, just for
Yes,
those
ma'am, I'm so
listening.
sorry. Sean Miller with the Kansas Land Title Association. The questions that you're raising now are the same ones that ULC and the National Notaries Association raised for us after the bill passed the House last year and as it came to the Senate. And that is essentially, are we looking at full faith and credit between jurisdictions as we move back and forth? We believe the language in here accomplishes that. We recommended the amendment that was suggested by the ULC. I also don't want to throw this too far off track, but while Dean Kincannon is a written-only proponent on this, I do believe he is on the WebEx because he's going to talk perhaps on the next bill, so he might be able to provide some additional expertise in this area. But essentially, Kansas would recognize the valid notarizations of any other jurisdiction, and those jurisdictions would recognize the valid notarization here in Kansas. Are some of those jurisdictions slightly different in terms of raised stamp, seal? Yes, they are. But the Uniform Act itself allows for full faith and credit amongst those various states and even foreign jurisdictions under the Hague Apostille that's in this legislation as well, and that it's in current law as well.
Thank you. Madam Chair, just how often are notaries reauthorized? How often do they have to be reauthorized by the Secretary of State? That may not be a question for you, but how often do they have to be recertified? How long is it good for?
I should know that.
I'm a notary myself, and I should know that too, but off the top of my head, is it 3 years? I think it's 3 years. Don't hold me to that, but I think it's 3 years.
Yeah. Thank you, Madam Chair. Thank you, Mr. Mayor.
Committee, yes, Senator Gossage.
Sorry, Madam Chair, I was just going to note that we did receive the email of his testimony with attachments.
Great, appreciate that then, committee, and those following online. It should be a PDF available of the written testimony from Mr. Sean Miller. Do we have other committee member questions for the proponent conferees? I have a quick question. We've been hearing a lot in Kansas about unemployment claim frauds and things. Is this bill, you're comfortable that it will provide safe, secure, robust authentication, if you will, for notarial acts that are occurring online? Mr. Miller?
Yes, ma'am. Sean Miller, Kansas Land Title Association. I think all of the organizations that have worked together to build this bill are, in fact, comfortable with the underlying technology. There's a number of technology companies out there that offer a platform like this. It is, because you mentioned the UI fraud, it is actually very similar to what the fix was that was when they took down the website last week and brought it back up with the multi-factor authentication that blocked the 540,000 fraudulent claims in the first day. That is essentially what, give me a little bit of levity there because it's a little different, but it's very similar to the dual factor authentication that most of us might be familiar with in terms of our credit reports and our credit checks as we're applying for loans. But I can provide the committee, if they'd like, with literally a YouTube tutorial. I think I did that on the House side last year. But it seems to be very well adopted. It's working in a number of other states, and there have been no concerns from those other jurisdictions at this time.
I'm glad you mentioned that video, because I was going to say, I recall in the House Judiciary Committee last session, we saw a video that actually demonstrated how the authentication process would work. And, you know, it's a face-to-face video, and if you could just explain to the committee a little bit about what documentation is required to make sure that's a secure transaction.
Sure. Sean Miller, Kansas Land Title Association. I didn't provide the video today or a link with my testimony because it is tied to a specific company. I didn't want to look like I was sort of prioritizing one tech provider over the others, but they do a pretty good job in the video explaining how it works. Essentially, it is a direct connect video. So you're on one end, the notary is on the other end. They do, in fact, require you to show your ID. Your face has to be visible. But before you ever get to that platform is the beginning of the dual factor authentication, where you're actually asked various questions that would appear in your credit report usually. You know, perhaps an address that you lived at 17 years ago, or the approximate amount of your current mortgage payment or previous mortgage payment or truck or car payment, those sort of things that can only be gotten from your credit record. Then it has to come up, they will actually have, you'll scan your ID, they'll have a photo of you, they'll have the video of you, they'll ask you a number of questions, essentially just to interpret whether you appear to be under duress. I mean, sort of the similar things that you're going to see face-to-face with a notary now. Why is this person so stressed out? I got a question last year on the House that said, how do I know there's not somebody on the other side of the computer, you know, forcing you to do this? And the answer to that is, you know, today, how do we know if somebody's not at your house, you know, holding something hostage, forcing you to do this? I don't know that there's ever a perfect system there, but there is that face-to-face general interaction through a live web feed. And then the recordings of all of that actually have to be kept, logged, along with the notary electronic log. So if that notarization is ever questioned in the future, just like we would look at your logbooks now and try to make sure everything's in order, we would have the ability to view that video log at that time, determine if perhaps there did appear to be some duress, or if you didn't seem to understand exactly all of your personal information, you know, whether you were working off of a fraudulently obtained record, et cetera. And then that would be kept in the record for forever so people could come back and evaluate.
Great, thank you. Senator Haley.
Thank you, Madam Chair. This is not for Mr. Miller. It's really actually for our revisor. And if he could briefly, if Mr. Thompson could revisit this briefly, why sections 33 through 35 are in this regarding proxy and precinct committee persons. That has nothing to do, unless Mr. Miller wants to opine how this, and that was the first part. The second part is, was this a part of the bill last year that came through the House? What does this have to do with?
I'm happy for staff to address. That is what I tried to address briefly. And
If you'll identify yourself.
Yes, ma'am. I'm going to further that out one of these days. Sean Miller, Kansas Land Title Association. Basically, if you look from page 20 on in Senate Bill 106, primarily what that is things that the staff revisor in the House side caught after we worked the bill and said, in precinct committee replacements, at one place in there, it allows for a proxy vote of other precinct committee men or committee women. And a proxy vote must obtain a valid signature as addressed by the underlying notarial statutes. Because we are doing a uniform law and a repeal and replace, that 53-509, I think, or whatever it is that references the valid signatures from notaries, may not be in 53-509 anymore. It may be recodified, it may be moved around. So what you're going to see in a lot of those places is as required under the revised uniform law on notarial acts. And that will cover the entire act as it's done. So there's a number of those things beginning on page 20 that run all the way through that were really just single cross-references in other statutes that reference the notary statutes that we have today. And because we are repealing all of those and replacing with 106, we had to change those statutory cross-references.
So this was part of last year's bill?
It was added, yes, Senator, this is Sean Miller, Kansas Land Title Association. It was added as an amendment by the House committee before it went to the House floor. It then passed the House floor 122-3. So it was in place when this committee heard it last year. Substantively, nothing to do with the underlying bill, but it's the statutory cross-references that are found in other places in the law.
Thank you, Mr. Miller. Thank you, Madam Chair.
Senator Gossage.
Thank you, Madam Chair, and thank you for being here. I'm not finding the word video in here anywhere. Is that something that was referenced?
Sean Miller, Kansas Land Title Association. I get it eventually, I knew. It is not. That is something that, as we're looking forward, video is obviously the standard right now, but those would be adopted in rules and regs. So the Secretary of State would be the one that would actually adopt those requirements, the allowable platforms that would work on them, and all of the individual requirements. So that would be done in rule and reg to provide that flexibility to the Secretary of State, so we don't have to come back every 2 years and fix it if the platform changes.
Thank you. And just to comment, Madam Chair, I too was a notary, and I think that video log that you mentioned is even more safe and secure than just somebody standing before you when you sign it. You have no log of that or what happened or if the person was under, duress. So again, it sounds like that's the standard. That's rules and reg that we can probably look forward to. Thank you, Madam Chair.
Committee, any other questions? Seeing none then. Thank you, Mr. Miller, and thank you to our proponent conferees who appeared today in committee. And I will ask then, do we have any neutral conferees either in the committee room or on WebEx? Seeing and hearing none, do we have any opponent conferees either in the committee meeting room or on WebEx? Seeing and hearing none, then we will close the hearing on Senate Bill 106. In committee, then, we will open the hearing on Senate Bill 122. If we could have a bill brief from our reviser, Mr. Thompson.
Thank you again, Madam Chair. Jason Thompson with the Revisor's Office. Senate Bill 122 modifies certain rules of evidence in the Code of Civil Procedure related to authentication of records and documents. I'll note for the committee that this is a Judicial Council bill, and it is a reintroduction of 2020 Senate Bill 334, which this committee heard last year, and then the Senate passed 39-1. It did receive a hearing in the House Committee on Judiciary, but it did not move out of committee on the House side last year. Essentially, there are no changes to what was written there last year, and not really any changes from the prior bill brief. Section 1 is KSA 60-460. That's the hearsay statute in our Code of Civil Procedure. There's some amendments there in subsection M related to business records. I won't go into too many details because you have a conferee coming who's literally one of the Kansas experts on this, and you've got my bill brief to lean on there. So I'll just kind of highlight the section 2 amends 60-464, the statute requiring authentication of a writing before it can be received in evidence. So that's what that section is about. Section 3 is 60-465. That's authentication of copies of official records. And section 4 is 60-467. That's an original document for proving the content of writing and exceptions to those rules. And I think that pretty well covers it. Unless you have particular questions for me, I'll stand aside and let you get to your expert testimony.
Sorry, thank you, Mr. Thompson. Did you provide us the history of this bill, or whether it was prior heard in either chamber?
Madam Chair, this is Jason again. Yes, I tried to. I'll restate that. I don't know if it came through. So it was last year, Senate Bill 334. It passed out of this committee. It was placed on the consent calendar and then passed 39-1 out of the Senate. And then it received a hearing in House Judiciary, which I believe Madam Chair was there for that hearing. I recall you having several questions on the bill, and it did not pass out of committee at that time, and so that's where it died last session.
Thank you, Mr. Thompson. Are there any other committee questions for the reviser? Yes, Senator Haley.
You were in that committee last year, Mr. Thompson. Was there a vote taken? You said it didn't pass. I mean, a lot of things died, procedurally because of our time. Was there a vote taken in the House committee, if you recall, on the measure that had been so overwhelmingly passed by the Senate?
Mr. Thompson, if you can answer.
Madam Chair, this is Jason again. I do not have a record of House Judiciary bringing the bill up for action or a record of a vote. So I believe it was just heard and then not worked, partially because they ran out of time, but also maybe because there were questions. I'm not sure, but the chairperson might be able to speak to that since she was a member of that committee as well.
Senator Pyle.
Madam Chair, Jason, who requested this legislation last year? The same as this year? Or okay, thank you.
Yes, Mr. Thompson.
Yes, Madam Chair, this is Jason. I'm nodding, and I know you can see me on WebEx, but for those just listening, yes, last year requested on behalf of the Judicial Council. Same again this year, and Professor Concanon is the main proponent last year and this year.
Any other questions for the reviser? Seeing none, then we will invite our proponent conferee, Professor James Concanon from the Kansas Judicial Council. If you'll introduce yourself, and welcome to committee.
Thank you, Madam Chair, members of the committee. My name is Jim Concannon. I am a professor emeritus at Washburn Law School, where I've taught evidence and civil procedure for 47 years. I'm appearing on this bill on behalf of the Judicial Council. I serve on its Civil Code Committee and was a member of the Ad Hoc Evidence Code Committee that proposed this bill. And what it does is to essentially conform the Kansas rules of evidence more closely to the federal rules of evidence on the two topics Jason mentioned, the so-called best evidence rule or original writings rule, and the rules relating to authentication. And because the bill is identical to the one last year, my testimony may sound familiar. The real impetus for the bill leads us to start with Section 4 of the bill on page 10, because this amendment addresses the problem with KSA 60-467 that prompted the Judicial Council to propose this bill. What we now call the original writings rule provides that when a party wants to prove a fact by proving what the words are that are in a writing, the party is required to produce the original writing itself rather than other evidence of what words are in the writing. And the only exception to that is if the party shows a satisfactory reason for not producing the original, such as that it was lost or destroyed without fraudulent intent. The rule can be traced back to the early 1700s, and it made perfect sense at that time. The only available other forms of evidence to prove the content of a writing were quite inferior to the original writing itself. About all you could have would be a witness who would give oral testimony from memory, who claimed to have previously read the document. And that person, of course, might have misread it or may not accurately remember it again. The other option would be a handwritten copy produced by someone looking at the original. But there are reliability and accuracy problems with that as well, because the transcriber might be inattentive or careless and thus transcribe the original incorrectly. When the federal rules of evidence became effective in 1975, of course, we had the Xerox machine and other reliable forms of duplication that had been developed. And so while Federal Rule 1002 still excludes oral testimony from memory or that handwritten copy unless a reason for non-production is shown, the federal rules added Rule 1003, which Senate Bill 122 would add as KSA 6467B. And it provides that a duplicate is admissible to the same extent as the original unless a genuine question is raised as to the original's authenticity or circumstances make it unfair to admit the duplicate. And we define a duplicate as a counterpart produced by a process that accurately reproduces the original. The problem in Kansas is that the Kansas rules of evidence were adopted in 1963 and in fact actually go back to the Uniform Rules of Evidence of 1953 when many modern methods of reproduction weren't invented yet. So the Kansas Code doesn't contain a provision comparable to Rule 1003 in the federal rules, admitting a reliable duplicate without requiring a good reason for non-production of the original. And the result is the Kansas rule can lead to the exclusion of reliable evidence, or at the least increase the proponent's costs to track down the original and produce it at trial. And this problem finally surfaced in the Patrick case that's discussed at the bottom of page 2 in the Judicial Council testimony. That was a prosecution for DUI. The police department had scanned the defendant's implied consent advisory form and stored it in as a digital copy in its records. When we got to trial, defendant objected to the introduction of a printout of that digitally stored form when a hard copy was not produced. And the Court of Appeals acknowledged that Federal Rule 1003 would have admitted the printout as a duplicate, but the court said our best evidence rule has not been updated for many years and does not consider scanned documents stored in a computer database to be the original document for evidentiary purposes. And so Section 4 of the bill would fix that by adding, in essence, the Federal Rule 1003 provision regarding duplicates. Now, the federal rules use 8 rules to cover the original writings rule, rules 1001 to 1008. Kansas covers all of that in just one statute, 60-467, and current subsection A covers so much in a 35-line paragraph that it's almost impossible to read. And so what this bill does is to break 6467 into 8 subsections, and it reorganizes the statute to improve readability. And in a few places, it substitutes the text of the federal rule for the current Kansas text, where the federal rules text is simply clearer. I won't go through all of those subsections unless you have questions. But given that the Judicial Council was recommending this change, it seemed that it was an opportune time to update and improve Kansas statutes relating to authentication, which is the requirement that before an item of evidence is admitted, the proponent must offer evidence that what's being offered is what the proponent claims it is. In this bill, Section 2 adopts, with one minor tweak, Federal Rule 901 as a substitute for KSA 60-464, and Section 3 adds a new subsection B to 60-465 to pick up the provisions on self-authentication that are found in Federal Rule 902, 5 through 14. Basically, 60-464 currently requires a party offering a writing into evidence to produce evidence besides the writing itself that is sufficient to permit the jury to find that the writing is authentic. This standard for authentication in Kansas is identical to the standard in Federal Rule 901A, but the phrasing of the federal rule is better because it applies that same standard to all evidence for which authentication is required, not just a writing. For example, a voice communication that is not a writing. Federal Rule 901 in B has a non-exclusive list of 10 examples that satisfy the authentication requirement. A Kansas court can today rely on those 10 examples because they really just reflect case law decisions. And indeed, the Supreme Court in the Robinson case, cited in the written testimony, relied on Federal Rule 901B4 in admitting evidence, but putting them in the statute as examples will assist Kansas practitioners in planning for authentication and make it easier through legal research to access federal decisions applying these examples. The only tweak is we kept the Kansas 30-year rule for ancient documents rather than the 20-year provision in the federal rule. Final changes in Section 3, which expands the categories of items that are self-authenticating. In other words, that don't require extrinsic evidence of authenticity beyond the item itself. Self-authentication doesn't mean that the particular item or document is admissible. You can still object to it as inadmissible hearsay or as irrelevant or inadmissible under some other rule. And of course, it can't override the criminal defendant's Sixth Amendment right of confrontation when it applies. Self-authentication just means that subject to the Sixth Amendment, it isn't necessary to call a verifying witness. We already have the concept in our current 6465, but that relates only to public documents. And so we kept those provisions, but pick up in the new subsection B the additional categories of self-authentication recognized in the federal rules. They don't come up that much, but they can save some expense when they apply. The last four examples resemble the provision that Kansas already has for certification of records produced under a third-party business records subpoena. And these provisions were added to the federal rule because of concern that without self-authentication, parties were often forced to incur substantial expense to call witness to authenticate a business record or an electronically stored bit of information, when ultimately no challenge to authenticity ultimately was made by the opposing party. All of these provisions were developed by the Federal Rules of Evidence Advisory Committee to the U.S. Judicial Conference, were subject to public comment and hearings that led in some cases to revisions. They were approved by the Judicial Conference for submission to the Supreme Court, which forwarded them on to Congress, which allowed them to go into effect. In short, they were thoroughly vetted. And I won't go through each of those in detail, but we'll be happy to respond to any questions that you have. With that, I would simply say the Judicial Council believes this is an improvement to Kansas law, will add clarity to it, and we therefore recommend the bill. And I'd be happy to take any questions.
Thank you, Professor. And I will then ask, do we have any other proponent conferees in the committee meeting room or on WebEx? Seeing and hearing none, then we'll open it up to committee questions for the conferees. Senator Thompson.
Thank you, Madam Chair. Thank you, Professor. A quick question on the self-authenticating evidence with regard to like newspapers and periodicals. Are we just authenticating that that is an official article, not that the contents are truthful, correct?
Yes, all we're talking about is if it's a published thing that looks like a newspaper, that's sufficient. The other side can still challenge it, but that's sufficient to establish its genuineness. But anything that was written in the newspaper, if offered to prove the truth of the fact written in the newspaper, would be subject to analysis under the hearsay rule. Yeah, it deals only with authentication.
Yes, thank you for clarifying that, Professor. When we're talking about authentication, we're merely, or are we, we're saying that the proponent of the document is authenticating that the document or item is what the proponent says it is. This is the newspaper article from December 3rd, 2020. That's what we're talking about when we're talking about authentication, not that the contents are true or anything about the contents other than it is what I'm telling you it is. It's a picture from the newspaper on. Is that correct, Professor?
Yes, that's correct.
And all those challenges to the content thereof are still available to the opposition or the other side, correct?
Absolutely. There can be an objection on the ground of hearsay, on the ground of irrelevance, lack of personal knowledge. Any of the other objections would be available, or as I said, in an appropriate case, even under the Sixth Amendment right of confrontation, where it's just avoiding the necessity of calling the publisher of the Topeka Capital Journal to verify that this in fact is the December 9th edition of the Capital Journal.
Right, and just because it's authenticated doesn't necessarily mean it's going to be admitted into evidence. But yes, Senator Gossage, you had a question.
Thank you, Madam Chair. Just a quick question. So much of the time nowadays with cell phones, people can take pictures of a document that was signed. They can take a picture of anything. Is a photo of the document admissible, or must it be like converted to a PDF, is a photo okay?
Professor?
Well, yeah, in terms of authentication, all the that would be established would be that this is a photograph that appears on the phone. In terms of the best evidence rule or the original writings rule that we talked about, a photograph like that could be treated as a duplicate, where the taking of a photograph accurately reproduces the original. So the photograph could be introduced to prove what the original document said, without having to track down the original document. In essence, that's what was involved in the Patrick case. They scanned the document, couldn't find the document, wanted to introduce a version of the scanned document, and because we didn't have the definition of duplicate, the Court of Appeals held that an objection should have been sustained to exclude it as violating the original writing rule.
So then the photo could be considered an allowable facsimile or an allowable copy duplicate of the original.
Yeah, again, it's possible that there's some other objection, that could be raised. That we're talking here only about, does this copy accurately reproduce the original? Is this in fact the photograph that was taken by this phone on that day?
Thank you.
To follow up with that question, Professor, if the person who took the cell phone picture of the document, would that person then have to come in and authenticate the photograph taken from the cell phone, saying, this is my cell phone, I took a picture of this document as stamped, as date stamped by my phone? Would we have to have that kind of evidence to authenticate this is a picture that I took on my phone of a document?
Historically, that that was the case. One of the parts of the addition of items of self-authentication, for example, if you look under B10, I guess this is on page 9 of the bill, talking about certified data copied from electronic device, storage medium, or file. The earlier one, a record generated by an electronic process or system. What's inserted here is a provision that could permit those to be admitted without calling the person who had the device, by using this certification process that, as I say, is similar to the process we have for records produced under a third-party business subpoena. The real key for all of these last 4 provisions in that regard, this doesn't preclude, even when an item is self-authenticated, it doesn't preclude the other side from challenging before the trier of fact the authenticity of the item. And thus, for all of these provisions, there is this requirement that before the trial or hearing, the proponent has to give an adverse party reasonable written notice of the intent to offer the record, make the record and certification available for inspection so that the party has a fair opportunity to challenge them. And that's where the protection is.
And that notice then to the other party is required when using this bill, if it were to become law, for any of the documents you're trying to authenticate. Is that right? You have to give the opposing party notice, hey, I'm going to provide a duplicate rather than the original, and here it is, and make your objections known to the court if you're going to object. Is that what the bill provides?
The language of in these federal rules provisions specifically requiring notice is applying to the last 4 of these items, which all involve admissibility based on a certification that the requirements have been satisfied. There's no specific notice requirement in the other provisions. I think they put it in here because it's obviously going to take some time to mount that challenge. The items in the first of these, you'd of course still have to be identifying any of these things as exhibits that you plan to offer at trial. You'd have to identify that in your pretrial conference procedures and disclosures under 6226.
Right. If I could, just one last question. How, in section 10 that you were referring to, section B10 on page 9, how does one get certified data or certification of a cell phone picture of a document?
Well, what I think that one probably would have been more under 9. What 10 is talking about is where what you've done is to say you've got information on a hard drive in a particular machine, and what you have done is create a duplicate copy of the information that's on that that hard drive. And what we're saying is a certification under 10 can be used in lieu of having to call a particular witness to say that the duplicate drive matches the hard drive. They do that, as I understand it. I'm no technological wizard about all of this, but they do it by matching hash values. That if there's any difference in the hash values in the purported copy versus the original, then that shows they're not identical. But if you've got the matching hash values, then that can be the basis of certification that they're identical.
I'm sorry. I do see in subsection B9 that you would have to have a duly qualified person provide that the certification requirements have been met, rather than just the cell phone or whatnot. So
that's right.
Thank you. And committee, any other questions? I thank you for your thorough presentation, Professor, and your thorough answers, and appreciate you appearing today. With that, committee, I will ask then, do we have any neutral conferees in the committee room or on WebEx? Seeing and hearing none. Do we have any opponent conferees in the committee meeting room or on WebEx? Seeing and hearing none, then we will close the hearing on Senate Bill 122. And committee, I just did want to circle back regarding Senate Bill 104. We were waiting to see whether the opponent conferee, Tanya Keys, the Deputy Secretary of the Kansas Department of Children and Families, was going to be able to join us by WebEx. And during the rest of the hearing today, we did get a note from Ms. Keys that she apologizes and asks the committee to please accept her written testimony. Her computer died, so we're not going to be hearing oral testimony from Ms. Keys, but it is in the committee folder and online. So with that, committee, I thank you for your attention, and for those of you listening online as well. And please be prepared to work the bills that we heard yesterday. Some of them, we'll try to work those tomorrow, and other ones we've previously heard. Yes, Senator Thompson.
Just one real quick follow-up on a request I made last week from Natalie Nelson, our researcher, regarding the Department of Labor, and she did send out information about how people could contact the Department of Labor to find out about any fraudulent claims. So I had a couple follow-ups for her, because I'm having a lot of people who are, they're wondering about when their unemployment payments are going to come in. They can't find out when that's going to happen. I don't know if Natalie could address that as well, or find out and get back with us. Also, is the Department of Labor going to identify or notify victims of ID theft that, who have reported the fraud, that the claims have been stopped by mail. So in other words, if somebody turned in the claims, how do they know the department is reporting and stop that claims? Also, are they going to issue any corrected 1099s in time for tax filings? And will they notify employers whose accounts have been affected that their accounts have been reimbursed and by how much? So we're just trying to find out. We have all these different questions by people about the fraudulent claims, and it would be nice to be able to get somebody either from the Department of Labor to answer these questions for us so that we can pass it along to our constituents, or if Natalie can get that information. You know, we just want to notify people so they're assured that, you know, they're not going to be victims of further fraud, and that they're not going to have to file or refile taxes with altered 1099s. And I appreciate the latitude, Madam Chair.
Sure. Thank you, Senator Thompson. Do we have Natalie Nelson from Research available who might be able to answer some of those questions or look into that? Natalie?
Madam Chair, this is Natalie Nelson from Legislative Research. So this isn't generally my area of expertise, but we do have other people in our office that handles this type of issue, and I can get with them and see if we can get get contacted with somebody in Department of Labor that would be able to better answer these questions. So I will be in touch with Senator Thompson.
Thank you. That would be very much appreciated. I likewise am hearing from constituents of this concern, and even from those outside my district with the same concern that this is kind of a systemic problem that we're looking at in the unemployment insurance benefits and within the department. So there is some information available if you have a fraudulent claim to report. You can contact me if you need to, or your senator if I am not your senator. We're all available and wanting to help. And we'll try to be working Senate Bill 60, which would help the state of Kansas prosecute those who are hacking or whatnot to steal the identity and make these fraudulent claims. So I would ask the committee to please be prepared to work Senate Bill 60. That was where if you are outside of Kansas and you come into Kansas and you cause harm to a victim here in Kansas, we have a new tool which would be Senate Bill 60 to help prosecute those kinds of cases. So with that, committee, then, thank you for your attention and your work today, and we are adjourned.